Why? Sorry. You reach Guwahati from Tinsukia, Dhubri. So therefore adjourn. We see no reason. If you have come from Dhubri, it is well and good. Why should he adjourn the matter?
Only for that day, next day, this week, any day, my lord.
No, let us take a look what it is about. If you need time, we'll grant you.
Lordship, in item number 2, we are required to file the affidavit, my lord. With the affidavit of the Deputy Commissioner Dhemaji and the SP Dhemaji, it's ready, my lord. We need 3-4 days time. Let it be taken
Let
off.
item be called. Wait for.
Lordship.
Wait for.
Lordship.
Item 1 for motion.
Yes, item 1 will appear.
Your mother, the report was called for, my lord. The report is here, my lord.
A report.
Report with regard to the, my lord, the
Dear Hazari is present for the court.
then inquiry officer was, my lord.
Petitioner claims that he specifically stated he was born in Azamgarh. He is from Azamgarh. But the police recorded that he is from Bangladesh. Why?
My lord, that's why, my lord, your lordship directed me to get the inquiry officer. Statement of the inquiry officer has been recorded, madam. What he has said, it is.
What does he say?
He said, my lord, he visited to the person concerned.
Very well.
My lord, then he asked for some documents he could not produce.
No, that is okay.
Yes, he has given some documents.
Suppose, Mr. Paying, I ask you from where you are from. You say you are from Azamgarh.
My lord,
Can I record it that you are from Bangladesh?
My lord, he himself stated he is coming from Bangladesh.
No.
That is the statement of the, my lord.
So now we'll cause a judicial inquiry. Then what else to do? And why should a man, if he is from Azamgarh, tell the police that he is from Bangladesh? Is it reasonably expected?
I don't, my lord, that is.
No.
That's why, my lord, we directed the.
We cannot do it. Police is supposed to make a fair inquiry. If you look at para 97 of Muslim Mandal, it's the word fair is used.
Yes, my lord, I understood, my lord, but what he has stated, I have not gone through the record yet, my lord. He has
No,
stated.
see, is it not a little unreasonable?
No, my lord, what he has stated, he visited the press.
No, visited, okay.
No, my lord, let me.
Mr. Paying, we have no doubt that the man visited.
Visited.
We
my
have
lord.
no doubt that the man conducted inquiry.
Yes.
We are not on that. Only one question. If the inquiry officer is informed by the person inquired that he is from Azamgarh, why will he write that he had stated that he is from Bangladesh?
I don't know, my lord, what he has stated before the police officer.
And why should a man incorrectly say?
I don't know, my lord, that is.
So
that is a
therefore,
factual part, my lord, we cannot.
so
I
what do
cannot-
we do? We order a judicial inquiry then. Let this say man faced it.
Let him.
See, for these simple causes, if the police would have admitted their mistake, we would have ignored the whole thing and determined the matter on its own merit. But as the police is insisting, so there has to be an end to this difference. Understood?
Understood, my lord.
Had the police said, oh, okay, yes, inadvertently I wrote it Bangladesh, he may have stated Azamgarh. That would have been the end of the matter.
That is not the case, my lord.
Ha.
He has said.
We would have then looked into the merits of the matter otherwise. But if this policeman making the inquiry, he's insisting, and he is insisting, no, I have not stated so, then we are bound to go a step further into this matter. Have you understood the consequence?
I understood. My lord,
And normally, why should a person who is inquired about whether he is a foreigner or not, if he is from Azamgarh, why will he wrongly make a statement, no, I am from Bangladesh? Definitely, it is not reasonably expected. Unnecessary, your man will be in a bigger trouble now. No. See, this is a formal court proceeding. Everything is on record. We cannot ignore.
yes,
Trying to save himself from a smaller mischief, now he'll get into a bigger mischief. Problem, this man. And then the next question will come, he'll be liable for perjury for making a wrong statement before the court again. We'll take up after some time. You confer with this man, tell him the consequences.
well, he is retired, my lord. The person is retired.
Maybe retired. Retired man cannot make a wrong statement before the court.
Let it come after then 1 week, my lord. I'll talk to him personally, the person concerned.
See, the next step is definitely something in the nature of a judicial inquiry. We will ask one of the magistrates to make an inquiry. Call him.
Yes.
Take evidence of both sides.
Let me talk to the person concerned personally, my lord.
But if he says that, yes, inadvertently it is wrongly written, that's the end of the matter. We'll decide the matter otherwise on its merit, not based on these statements.
That's, let it come after 1 week, my lord. I may get. Because
The report of the, whose report is it?
this is, my lord, the statement of the Fazul Haq, the then inquiry officer. As
As required by the order of 1/3/2023,
The SP border has submitted. it.
the SP Kokrajhar.
Yes.
SP border Kokrajhar has submitted a report which contains a statement of Faizul Haq, the sub-inspector of police border who had conducted the inquiry. And as per such statement, there is a reiteration by Faizul Haq that the petitioner proceedee had informed him during the inquiry that the proceedee is from Bangladesh. Mr. Paing seeks for an adjournment to confer with Faizul Haq on the veracity of the statement made by him.
After one.
After one. Sometimes, Mr. Paing, to escape from a smaller trouble, you get into bigger trouble for nothing. And these are actually inconsequential. Whether he had stated he's from Azamgarh or he has stated he's from Bangladesh is most immaterial for this writ petition,
Yes. there is-
because we will decide his matter on his own merit, whether he can prove he's citizen or he cannot prove he's citizen.
That's true.
Item 2 for admission.
Question. Yes, yes. Faizul Haq Najem Pandey has already here. Yeah, Faizul Haq is retired, so I. Taking an original question, so my.
This is the matter.
What is this matter? Some
This is a custodial death matter.
custodial.
The prayer made is that for an inquiry and for
Who
compensation.
appears for the petitioner? None. None appears for the petitioner. Mr. D. Nath, learned senior advocate,
I prefer 1 week.
prays for a week's time to file the affidavit as required by the order dated
23, 23,
23/6/2023.
6.
This after a week.
Logic.
Item 3.
My lord, the petitioner is
Petitioner to produce any relevant material if ever we prove that the family of Iman Ali had shifted from Thakayapara to Sunkurihara. Any material do you have?
yes, my lord.
Where is the material?
Voter list of 1985,
Page number
I have submit by way of additional affidavit. No, 2 weeks time is required.
One time.
2 weeks.
You are
SC Pandit.
SC Pandit, like on the petitioner, 6 for not 2 weeks time, it's a 2017.
I am going to Hyderabad for treatment for 1 week, my lord. Tomorrow I will go. 2 weeks.
2 weeks time to file the information as required by the order of 14/6/2023.
Item 4. 2 weeks. I'll go to 1 week.
Election Commission 16.
Question is written as to produce the complete voter list from 1966 to 2015.
Produce the origin of the 66 voters list.
As regards the origin of 66, we have received the origin of 1970. The officers told me that they have from the NRC version, but 66 they have not received as of now. So they provided me the
Anyway, complete voters
Com-
list.
that has been produced. Provided.
What, how does it help the petitioner?
And linkage is established, Your Lordship, because his entire family, the petitioner claims that he is the son of Isab Ali. Isab Ali's name appears in the voter list of 1966, Your Lordship, in serial number 76.
It is here.
Yes, Your Lordship. In page number 1 is the 1966.
76 Isab Ali. Yes.
Isab Ali.
Isab Ali is the
Isab Ali is the father of the petitioner. Your Lordship.
father.
Your Lordship, therefore, if Your Lordship comes to page number 4 is the 1970 voter list. Then in page number say 4 itself in round.
27 again Isab Ali.
Isab Ali, Your Lordship.
Huh.
Therefore, Your Lordship, in 77, Isab Ali's name again appears in page number 10, Your Lordship.
No, Isab Ali is the father.
Father.
Now,
And
who is the petitioner?
Petitioner is
Hazrat.
Hazrat Ali, Your Lordship. Then
Does the name of Isab and Hazrat
Isab
appear?
Ali and his wife name appears together, Your Lordship.
Sorry.
There, Isab Ali and his wife,
Which
Amir-
page?
it is in page number 12, Your Lordship, 79. Amazon 280 is Isab Ali, Your Lordship.
71, 79.
79.
Isab and Amirzan.
Amirzan.
Amirzan is the mother.
Mother.
Isab father. And
And Your Lordship, therefore, in
does the name of Amirzan and
Hazrat-
Hazrat appear
yes,
together?
in page number 17.
17.
17, Your Lordship. Total is 89. Amazon is 555 serial number. Page number 17, serial number 55.
Amirzan, mother, Hazrat,
Hazrat Ali.
petitioner. Yes, Madam Baru,
I remanded that
go back there.
the tribunal will look into the matter. Lordship.
You heard H.
A.H. Alamgir.
A.H. Alam, Land Council for a petition. Put him. The petitioner Hazrat Ali had been referred to the foreigners tribunal number. Where is the order? Page number?
Is 65.
Admin. Refer to the foreigners tribunal number 7, Nagaon at Lanka, for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of FT (L) case number 1455/2017. The tribunal rendered an opinion dated 26/7/2018 declaring the petitioner to be a foreigner. Being aggrieved, the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1960. In the writ proceeding, in order to verify the claim made by the petitioner based upon the voters list of 1966, 1970, 1979, and 1980. 89. 89, 89, I think, page 17. 89 of village Tengaguri, Kosari Gaon, police station Lahorighat in the Nagaon district. We required the election commission to produce the complete voters list of the aforesaid years in respect of the said village. Accordingly, the complete voters list have been produced before the court. Perusal of the voters list makes it reveals that then produced The petitioner relies upon the voters list of 1966 of village Tangaguri Kosari Gaon, which contains the name of Isop, son of Asraf at serial 76, and it is claimed that Isop is the father of the petitioner. Further reliance is placed on the voters list of 1970 of village Tangaguri Kosari Gaon, which again contains the name of Isop, son of Asraf at serial 67. Further reliance is placed on the voters list of 1977 of village Tangaguri Kosari Gaon, which contains the name of Isop Ali, son of Asraf at serial 284, and that of Amir Jan, wife of Isop at 285. Which information is also available in the voters list of 1979 of village Tangaguri Kosari Gaon. Reliance is also placed on the voters list of 1989 of village Tangaguri Kosari Gaon, which contains the name of Amir Jan, wife of Isop Ali at serial 55, and that of Hazrat Ali, son of Isop Ali at serial 58, and both are shown to be residing in the same house number 8. Petitioner accordingly claims that as his name appears along with Amir Jan, wife of Isop, in the voters list of 1989, and the name of Amir Jan appears along with Isop in the voters list of 1977 and 1979, whereas the name of Isop appears in the voters list of 1966 and 1970 of the same village Tangaguri Kosari Gaon. The burden under Section 9 of the Foreigners Act had been discharged by the petitioner. In view of the above, remanded back to the tribunal to examine the complete voters list of 1966, 70, 77, 79, and 85 of village Tangaguri and pass a reason order thereon. The respondents in the Home Department may make their inquiry, make their verification, and submit a report before the tribunal, if so advised. Upon doing the needful, reason order be passed. The complete voters list produced before the court is kept on record. Yeah. I will. What is the IA for?
I lordship.
643. Why was it filed?
In the time of execution, lordship, advocate was died. That's why the petitioner person is due to that of his advocate, the case is
Huh?
adverse.
Advocate inadvertently died.
Advocate name is
How can he die
Amarendu
inadvertently?
Das.
No, that is okay. He must
He was
have
died.
died, but what is the prayer?
He was-
Petition should not be issued setting aside the costing the injury. In view of the order passed in WC so-and-so, data so-and-so, no order required to be passed, I closed.
Item 5.
Yes.
May please your lordship, the petitioner is the Aziron Nessa. Her
Hmm.
father name is recorded in the 66 Border Space Lordship.
Page
37 lordship.
37.
Moishonder is grandmother,
Janab Ali is the father
father,
and
Zorina Khatun mother,
Jorina Khatun mother.
and Moishonder is the grandmother. And lordship, the space lordship,
This is of 1966.
66.
Village is
Dakaliapara.
Thakalia Para.
Lordship, space
So
lordship,
who is the petitioner? Aziran.
space 39 lordship, 70 border lordship.
Please. No, that is okay. Which document will show? Aziran is the
The-
daughter of
Lordship, the
Janab.
brother was examined lordship. Brother name is along with the father lordship, space 41 lordship.
Is 41.
Barning lordship.
Saraf Ali.
Sorobali lordship,
Saraf Ali is the brother.
brother lordship. And the lordship, space lordship,
You
61 is the evidence lordship.
you
Sorobali.
produce the complete voters list because from 66 to 97 straight away.
No.
What do you do?
the petitioner's name could have figured lordship. Because we do not know if she is their daughter, nothing on record to show that. He's claiming that the father, mother and the projected brother.
Hmm.
What about the other siblings if they are there? Why is she the only sister or how many children this Jonab Ali and Jorina Khatun had in lordship? Just making somebody the brother and showing that he gave evidence does not give him the right lordship. Nowhere is no other mention is there, no other document to show she is this daughter or sister.
No, but how do you discard the evidence of Saraf Ali?
How do we know he is his own sister? The petitioner is.
No,
his
he
own
has
sister.
given evidence before the tribunal, so he has to be cross-examined.
Cross-examined and whether.
Otherwise, law of evidence provides for oral evidence.
No.
And if somebody has given evidence on oath, you just can't say that I am not accepting that evidence unless some contrary material is there.
What was said before the tribunal?
I understand the apprehension you have raised. Maybe you are right also, but how can we discard the evidence on record? Suppose the state would have produced some further evidence and that evidence is in contradictory to this one, then we'll reject it.
The burden is on the proceeding.
Understand? So he had discharged the burden.
And he has failed to prove lordship.
No, he had discharged the burden.
Any other document
Yeah,
if he can bring
lordship,
before
the-
this court lordship,
Page 47, the school certificate was exhibit lordship.
page.
Page 47.
If that is also lordship called for,
The lordship, the exhibit before the tribunal lordship.
was it examined?
Exhibit 10.
No, was it thing?
Where is Madam Dekagon? Let us call for the school register.
Yes, lordship,
No?
something.
The petitioner also relies upon a school certificate, which is exhibit 10 at page 47 of the writ petition. To substantiate that, the petitioner Ajiram Nessa is the daughter of Jonab Ali of village Dhakaliapara. Dhakaliapara. The district elementary education officer of which district? Bagbor of Borpeta, to do the needful to make the admission register in origin of the what school?
It is lordship Uttar Moinabari Chowk Girls Primary School,
sorry.
page 46. Page 46, lordship will come to page 46.
2003 number Uttar
of the-
Moinbori
2003
3.
number Uttar Moinbari Chowk Girls Primary School being made available to the court. A copy of this order be provided to MSB Decca, Learned Council for the Education Department for doing the needful. List on.
Item 6.
Use the register and the certificate. Then it will become clear whether if she has read in that school, the register will show lordship. And the certificate is proof that she has left the school. Let us hope we get.
Register in
complete
original
lordship.
as well as the certificate. Jubar Ali.
In this case.
Petitioner relies upon a voter register 1970, of which contains the name of Korim Boxa. Son of Miyazan is showing his issue for the reliance of.
You filed something? No. No?
Why Sugita Nesa name was not there in 1970?
That information I could not collect yet, Lordship. For that, I need some more time, Lordship. Otherwise, his name is.
R. Chaudhary, Land Counsel for the petitioner, seeks for some further time to provide the information as required by the order of 19/6/2023.
2 weeks time. Obliged.
No, normally, usually her name ought to have been there,
Lordship, as her age on.
considering the age of the person in
1970.
73 and 60 years in 1970.
Maybe immediately after marriage, her name was not included with husband, Lordship. For
Possibility.
that, I have to take instruction. Lordship.
Then you show her name in which voters list
father's
it appeared along with the father,
Lordship. Obliged,
and in which year they got married.
Lordship.
Item 7.
That's it, the matter be passed over for the time being.
Time being, why?
Lordship, my senior is another construction.
You make an attempt.
Lordship, I have not gone
Seven
through the
hours.
records, so I'm very informed.
Go through the records.
Yes.
Item 8 for hearing.
Did you? Yes, Mr. Shigar.
My lord, in this case, the petitioner Mokram Ali, he is all along voters in 1972 onwards in village Kadamtala.
Hmm.
Lord, you will find the 70 voter list at page 24.
Page 24.
Yes, my lord. Mokram Ali, Abdul Jalil. All along, my lord,
Mokram Ali, he is the father.
my lord, Mokram Ali is the petitioner himself.
Mokram Ali is he himself is the
Yes,
petitioner.
yes, my lord. He is elderly
Okay.
person, my lord.
Ah.
72 onwards, my lord, in the same village, my lord,
Hmm.
Padamtola.
Where is the notice of the tribunal? To whom it was issued?
My lord, notice, my lord, notice, lordship will find at page 17. My lord, after 2016, my lord, he shifted to the village of her father-in-law. And the notice is given in that village, my lord.
Why did the tribunal reject this?
My lord, the in order, lordship will find.
নিজে বুলি কৈছে।
Evidence of the opposite party, lordship will find at page 59,
Hmm.
paragraph 6. The evidence of the opposite party and DW2 and DW3 are not coupled with above mentioned documents. There is nothing to believe that the
On perusal evidence, the exhibit shows the name of parents of the opposite party in the name of the opposite party. These are all irrelevant material. Once a man says that I am Mokram Ali of the 1970, you either decide he is that Mokram Ali or he is not that Mokram Ali.
One and the same person.
That's the only thing to be decided.
Lordship may remand it back
I
and
think,
with the police
I think
verification
it's,
whether it's one and the same person.
Is what a hearing. Heard Mr. A. Heard Mr. A. Sikdar and counsel for the petitioner also. The petitioner Mokram Ali had been referred to the foreigners tribunal number
at Golpara, at page 56.
number 5 Gwalpara for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, being aggrieved resulting in registration of FT case number FT/5/106/MA/2016. Tribunal rendered an opinion dated 23/7/20 23/7/2017 declaring the petitioner to be a foreigner, being aggrieved, the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1970 of village Kodamtol Nongke, which contains police station Bagbor, Moza Bagbor in the Borpeta district, which contains the name of Makram Ali, son of Jalil at serial 230. Petitioner claims that he himself is Makram Ali of the 1970 voters list. The name of Makram Ali also appears in the subsequent voters list of village Kodamtol Nongke. It is stated that in the year 2016,
My lord, 2016.
the petitioner migrated to another village, namely
My lord, in 16 also in Kodamtola, then my lord, he shifted to Mahmudpur in Gwalpara district.
to another village, namely Mahmudpur in the Gwalpara district, which in fact is the village of his father-in-law. And notice was accordingly served to the petitioner Makram Ali at his present address at village Mahmudpur.
My lord, Mahmudpur within bracket Shantipur Nigam.
Mahmudpur within brackets Shantipur
Shantipur
Nigam.
Hmm.
What is Nigam?
I don't know, my lord, they given address like that.
Nigam is corporation. Nigam corporation হয়ে যাবে।
Given address, my lord, like that, my lord.
নিগম বুলি কয় নেকি? আচ্ছা এইটুকু নিগম কয়। নিগম। Although certain other evidences were rendered by the petitioner before the tribunal, and the petition and the tribunal found that the evidence of DW 2 and 3 are not coupled with the other documents referred by the petitioner, but the core question as to whether the petitioner Makram Ali and the Makram Ali of the 1970 voters list of village Kodamtol are one and the same person had not been decided by the tribunal. For the aforesaid reason, we remand the matter back to the tribunal to give appropriate finding on the said question as to whether the petitioner Makram Ali and Makram Ali of the 1970 voters list of village Kodamtol are one and the same person. And accordingly, pass a regional order.
Develop.
The respondents in the Home Department may also make the verification and submit a report whether the Makram Ali, the petitioner, and Makram Ali of that voters list 66 of are one and the same person.
Develop.
Item 9,
None appears for the petitioner when the matter is called. List again on subsequent call. If none appears, appropriate order shall follow.
item 10,
And for the last occasion, your lordship was asked to obtain instruction as to whether how a person can possibly in the year of at the age of 63 years.
Last occasion, only order is list on 18/7/2023. 31/5 petitioner relies on order.
Well, anyway, lordship, I am submitting lordship 1960 voter list is at page lordship 19. The voter list of my parents, father and mother.
So if the mother is Alekjan,
Right.
who was 32 years in 1960,
My lord,
and Moinul Haq was born in the year 1991,
my lord,
Alekjan must be 63 years old.
my lord, that was the question on the last of.
What is your answer?
My lord, what happened was there are some certain discrepancy in the age of the pair of your mother lordship. In the voter list of 1970 also, some differences is there lordship. As per voter list of 1970, her age was lordship at that time 58 years.
So
My lord,
That means in 1991,
my lord.
she must have been say, 79 years. That is even worse for you. How does it help you?
My lord,
So when the petitioner was born, the mother was 79 years.
no, lordship, it will be 58 years as per the.
No,
Bottom
no,
of
if in
1970.
1970 she was 58 years,
No. On lordship, at the age of 58 years, petitioner born.
so 63 and 58.
Madam.
63, it is not possible, 58, it is
58,
possible.
at appears.
Where is the medical?
My lord, I have submitted an application before the superintendent of lordship, GMC, seeking certain opinion regarding that aspect, lordship.
Why should the GMC respond to your application?
Well, otherwise, lordship, I have petitioners no option, lordship, work for lordship, you will collect lordship.
How is that? No? Yes, madam, what by any idea you have? What is the maximum age when a woman can conceive?
Lordship, there are instances that women have given birth up to 60 years, but very rare cases, Lordship.
So how, what do we do with this matter now?
Now, whether the petitioner.
What is
the
what is
biological
the
son.
age of your sibling who was born prior to you?
Yet I have not any age. My
And
lord,
how many siblings, maybe elder or younger, that may help us, Lordship.
my lord, I have given the name of the sibling that is.
No, no, what is the age?
My lord,
Suppose Moindal was born in the year 1991.
yes,
When were the other siblings born?
my lord, that is.
Find
That
out.
instruction, lordship, I have
And
not-
whether the names of the other siblings figured with the parents or not, that also helps the petitioner, Lordship.
that is-
And whether. any
But
one of
otherwise,
them-
how do you expect us to, within the present material, how do you expect us to
rare-
pass a order
rare
in your
cases,
favor?
In rare cases, certainly circumstance, lordship,
Then you have to prove that this was a rare case.
my lord, we have pay lordship,
Hmm.
some inquiry.
See, when a regulation fact is brought in on record, it is accepted. But when, as per your own words, if it is rarest of rare event, then you have to prove it,
My
whether the rarest of rare had actually taken place or it has not taken place.
my lord, may I pray lordship some
See,
inquiry?
going to the moon is one of the rarest of rare events. It doesn't take place every day. So whether our Chandrayaan-3 had actually gone or not, that's a matter of fact.
My lord,
But taking a bus and going to Hazo or Nalbari, it's a regulation feature.
my lord,
Every day, hundreds of buses must be traveling. So that is not a rarest of rare fact.
that's why may I pray. lordship,
So rarest of rare fact has to be proved separately.
my lord, that's why lordship, may I pray lordship, some inquiry may be directed to.
But the
Who will
parents
conduct the
also-
inquiry?
Through the SP of the concerned district lordship, and the report may be submitted. Lord.
Lordship,
The
first
petitioner has no
issue
option,
is
lordship.
we have not overcome. How the lady at 58 years, she has given birth, whether she is the biological mother or not. Both are not there. What inquiry will the police do, Lordship?
My lord, they, lordship expired. Prior to
These things
2000
are not
So
documented, Lordship.
you will have to prove it. How can you shift the burden to them
My
to
lord,
prove your case?
My lord, one of my cousin brother was examined. He was lordship, that is space.
How do you know he is the cousin? How do you know that he is telling the truth? How do you know that he knows these medical facts?
And his
Well, if
own
he's
brother.
just because
own
one-
sister.
X person comes and says something.
My lord, he is the, at the age of 60, his age is 65 years, lordship, cousin brother.
How does it matter?
My lord, he is,
How do you know he is the cousin?
my lord,
Firstly, you have to show how that he is a cousin.
my lord. he
And
is-
cousin means the exact relation. Cousin is a vague word.
Right.
There may be thousands of different kind of cousins in this world.
Grandfather of the petitioner and grandfather of the cousin lordship are brothers lordship. They, as per the deposition lordship, before the,
Have you established that fact?
my lord, that's,
Is that fact established anywhere?
my lord, that's why lordship,
That-
may I pray lordship, some direction may be given to,
Why should you
What
give
are
it
they
direction?
doing?
Sorry, no,
and submit the.
that
report.
is against the principles of a jurisdiction.
My lord,
Just because somebody comes and makes a vague claim,
my lord, I have annexed the birth
order a
certificate
direction.
also.
We cannot do that.
I have annexed the birth certificate. That was lordship, officer was called for examination. They said that
No, no,
the
birth
documents were
certificate,
banned.
birth certificate shows you were born.
My lord.
No doubt you were born. We don't doubt that the petitioner was not born.
In the voter list of 1970,
How does it help you?
1970. Others-
Mr. Khan, in other words, you were just going directionless. Whatever is coming to your mind, you are speaking it out. Speak something logical
My lord.
and acceptable in law.
But we accept 1917 voter list lordship.
If you don't have, then you face the consequence. So we declare you to be a foreigner.
And sometime maybe given lordship, I will have the.
How much time should we give you? We have already given you twice time,
But 3 weeks time maybe.
not 3 weeks. Time was already granted on 2 occasions for the same purpose. And granting of time is not unlimited.
The last purpose is lordship tools. I'll try my best lordship within 2 weeks. If some documents.
No, you should have tried because we gave you time on 31/5/2023.
Yes.
That is almost 2 months back.
Lord, I am.
Whatever you wanted to try, you have tried in the meantime.
I am waiting for the communication by the superintendent of the GMC lordship, but he has not furnished.
His
Just
other
making a vague
siblings-
application, court can't keep on waiting for that.
If his other siblings have also been served with the notice, that is also, because if he has been served, the other siblings must also have been served. That information also we do not have. Because the parents are not there, the projected parents are not there. So my friend need to tell this court whether the other siblings are also,
Does he have sibling?
he has shown it in the chart, one brother, one sister. Paragraph page 4, lordship.
Yes,
Page 4, he has shown grandfather, father, mother, brother, petitioner, daughter and son. So what about the other siblings, whether they have also been declared or not? Because the same set of documents would be available to all of them.
all of them, Faisal Haq is the brother lordship.
Whether Faisal Haq has also got the, has been referred as a foreigner.
No.
No,
You make an inquiry, make a reference.
no, I don't want to do that. I'm trying to help him out. If he has knowledge about his other siblings.
No, lordship, I have
And his
instruction on
own
that.
brother
aspect.
has not deposed, but some cousin has come and deposed. So that also raises a question mark, lordship.
So Khan, you better face the consequence of being not a
Lordship,
citizen.
it's a fit
Well,
case
I
to be dismissed, lordship.
by way of filing an additional affidavit, why Faisal Haq has not come lordship for deposition?
The writ court is not supposed to make roving inquiry into all these things. It is for, we are not even required to go to that extent, but still, to be fair to these people, we are giving you more than adequate opportunity. Please bring any material you have before this court also. We are going to look into it. But that doesn't mean you go on making all kind of vague inquiries here and there. Why should you do it? Under which provision of law it should be done? Writ law does not say a person will come to the court, make a vague claim here and there, then the onus is on the respondents to make an inquiry and tell the court. That is not the writ law.
In the voter list of 2017. Page lordship,
That doesn't help you in any manner.
2017, page 26 lordship,
That will not help you in any manner.
showing the name of my father.
Doesn't matter. This voters list Ask Mr. Ali, frankly, it can be obtained at any time you feel like.
It's a single name voters list. His siblings' name also do not figure. Let him come up
Just
with something concrete,
one
Lordship.
week time may be given, Lordship. I will.
So we impose a adjournment cost. We can't go on like this. So on 2 occasions, we have given you a appropriate opportunity to bring whatever you want to bring. And this cannot be a never-ending process. That unless you can bring some document at a future date, court is going to keep on adjourning the matter, giving you opportunity after opportunity. Nothing like that in law.
That only because, Lordship, I asked for, I think that's why, Lordship.
That will not help him.
That's why we
Lordship.
gave
That-
you,
That one sounds, Lordship.
that's why we gave you enough time earlier.
Only one last chance, Lordship.
Why?
Next week, any date, Lordship. I will try my best, Lordship. Monday or Tuesday, Lordship, no problem.
List on fixed date at the DBO. Fixed date. On the prayer of Mr. M. Khan and counsel for the petitioner, who makes a request that a last opportunity be given to the petitioner to produce any relevant material to show that he is not a foreigner under the Foreigners Act of 1946.
Master Lordship.
Reference is also made to the earlier order of 13/5/2023 when the matter was heard.
25th July. Item 11,
Madam President, Lordship, example of one matter. Lordship query on the point of that founding son, actually 100 many
Just a minute,
matters,
just a
many
minute.
things actually procured.
Just a minute. Right. Oh, that abandoned at Dharamtul railway station.
Yes, yes. Subsequently, he was actually brought up by our two community persons. Ultimately, he married from one community, and that wife is expired a few days before. And prior to 1925, that marriage actually took place and all things. These are the submissions, but at the same time, Lordship answered for
Yes.
me that I should satisfy the Lordship about founding son. So I have actually brought out many international laws on this question and found so many documents. Actually, it was actually printed today. He was suffering from very high fever during the this. And another was the trust that he could not actually, for just this copy, actually, I could not procure. So maybe given another chance, another date fixing.
Mr. Huda, sum and substance, you want an adjournment?
Yeah, we will talk about it. Please,
No, sum and substance of what you are submitting, that you want an adjournment.
Adjournment.
Thursday, Lordship, day after.
Day after? Day after. So that's it. That is-
List on so and so on the prayer of Mr.
Right.
Huda.
Thank you.
20 July. Item 12,
But have you gone through the facts of that matter?
I've just seen the order, Lordship.
See that, read that order of
last
1/6. We have, into details.
Yeah.
Please read the order of 1/6. I think we have recorded the fact.
Yes, Lordship, we have taken it.
Hmm.
We have taken this copy. Lordship, it says the factual case.
No, he says that this was the abandoned person. Somebody,
Adopted.
one Abul Hussain picked him up, brought up the person in his own tradition and culture. Then another person
And
adopted him. He again brought him up in the culture of that person. The person is again reverted back to the original person. All that we can explore is whether this fact claim is true or
True.
false. We cannot go anything beyond that. Suppose it is false. He is an abandoned person who doesn't know who he is. Suppose it is true. Still, he is an abandoned person who had been picked up by Abul Hussain. What will be his citizenship?
Lordship, this is the story, they have come up before this court.
No, that's why I say,
We can call the police inquiry.
No, no.
to Actually find out.
understand. What will the inquiry reveal? Inquiry will reveal either it is a false claim
whether
or
the
it will
story-
be a
Yes,
right claim. Under both circumstances, whether it is false or whether it is true,
yes, Lordship.
if this man is an abandoned person who doesn't know who he is, how will you determine his citizenship?
Lordship, the LCR is there. If I would like to just go through the LCR to see what was his statement before the police. I see in the cause list that the LCR is there. Yes, let us go from where it came.
Go to it, see what is LCR to the option.
The police, what was his statement before the police? What did he state? If he's abandoned, that is subsequent part of this story. What was his narration submission before the police now?
Find out what he said. People will know. Mhm. This issue is something much bigger
Yes, Lordship.
than all this, what he stated, what he not stated and all.
He has stated he's from Bangladesh and FIR was
No,
lodged against
That
him.
doesn't matter.
Yes, Lordship.
That also doesn't matter because that statement is not on evidence. And neither it proves anything. Whatever he may have stated before the police, and now after one previous matter, the police writes whatever they feel like, you have to look at it with a little bit of doubt also. Suppose he stated before the police he is from Bangladesh. Now, once he states he's from Bangladesh, that is not the end of the matter.
Yes, Lordship.
That is only the beginning of the matter. That based on this statement, he'll be referred to the tribunal. Once the person is referred to the tribunal, Section 9 of the Foreigners Act comes into play.
Yes, Lordship.
So the burden is on this man to prove that he is
Citizen of.
not a foreigner.
Yes.
No, you put it the other way nowadays. Is that he is not a foreigner under the Foreigners Act 1946. Now, if this person is actually a person, abandoned person who doesn't know who he is, how can he discharge the burden under Section 9 to prove that he is not a foreigner? Meaning thereby, we are calling upon an impossibility to be performed by this proceeding. This is why I said it's a bigger question.
It is.
You law says no one can be compelled to prove the impossibility. This is where we feel looking 3 or 4 steps ahead.
Yes, Lordship.
We are asking the person to prove an impossibility. So that's a, and law says you cannot compel anybody to prove an impossibility.
Lordship, going by what is here in the record.
Understood.
It's at 95 and
Madam Verma, please come to terms. Whatever may have been stated that
he has come into India after 25th March 1971. It is his statement. And Lordship will see at the inquiry report, it's in vernacular, my friend will read it. Whatever I have read in English, it says, it is his statement that he has come to India.
Statement before the police.
Yes, somebody had lodged an FIR.
Just a
lordship.
minute, is it statement before the police?
It is under section 172
172 of
of
what?
CRPC.
172. Sound 172.
Case diary lordship, it says case diary under section 172.
Let us see. What is 172? Case diary in the proceeding. Every police making an investigation shall day by day enter his proceeding in the investigation in a diary.
It is-
So
Yes.
that means this is an entry by the police in the case diary. It is nothing beyond that. And the entry by the police in a case diary. His lordship is here with the entire experience of the criminal CRPC background.
Definitely.
It is not a material on evidence to be taken note of. Number one. Number two, it can be based on a statement made by a person during investigation under section 161 of the CRPC. Section 161 is not admissible in evidence. So this has no value for us. So that's why, Madam Verma, we had clearly expressed concern that this is a much larger issue.
And I'm
It can't be
sure
decided just on one line here or one line there.
Lordship will also.
I
go
think
into
we
it.
have to,
Yes, and if required, these policemen or anyone can be summoned.
no,
before this
no,
court.
even if it is summoned, it is of no use. That is the difficulty. Think a little larger. Make a more holistic thinking,
Yes, Lordship.
not just confined to
Lordship, the
the
records,
usual cases.
the records even show
Mhm.
he had approached this court in 2010. There is an order of Justice Sharma here, passed in 11/9/2015. I've not gone through it.
What is it?
May I read it, Lordship?
No, what is it?
It's an order, it was in the writ appeal which he had filed. And against that order, I think he's before this court. We don't have the,
Order in a writ appeal.
in a writ petition. Yes,
Single bench,
Lordship.
refer to single.
What is this proceeding? Oh, it's a writ
Same-
appeal.
Same, this person, Lordship.
So it's a order in the writ petition has no value because we are in appeal.
At that point of time, single bench was taking up FD matters.
Understand?
Lordship.
It has no evidentiary value. That's a judgment in appeal. That will not give a legal right either this way or that way to either of the party.
Then again, he had come up in a writ appeal.
Madam
also.
Verma, in other words, please appreciate when we express something. There is a definite meaning, purpose, and purport when we say something. This matter cannot be resolved based on these materials. That's all.
What else Lordship is suggesting? What,
Mm.
how more can we assist the court, Lordship, on this?
So
Lordship will show us the way.
the way out is, in spite of all these statements recorded by the police here and there, whatever he may have stated, ultimately it will result in a proceeding before the foreigners tribunal. In the foreigners tribunal, he'll be given complete opportunity to discharge the burden under section 9
Now,
that he is not a foreigner.
yes.
If his stand is that I am an abandoned person, I don't know who I am, meaning thereby you are asking this person to prove an impossibility in discharging section 9. This is where we are having a little difficulty in proceeding further. So law says no one can be compelled to prove the impossibility.
Yes, Lordship.
So that means section 9 burden does not work with this person now. Now what will you do? This
Yes,
is the issue before the court. Now what will you do? Submit on that, not what had happened earlier. I think you'll have to,
We'll have to go.
you will have
deeper
to
into
apply
it,
your mind
Lordship,
and tell us.
And we'll have to go in completely into the records also.
Record, nothing will come out.
2006.
Nothing will come,
Ex-party order against him.
nothing will come out of it, madam.
The Lordship will give us some time.
Mm.
We will go into the records. We'll get a
So
copy of the writ appeal also.
we can almost tell you, no, those records will not help you in deciding this question.
Lordship, the story which my friend has put up before this court that he has been abandoned. This is one of the many stories which the illegal migrants have taken up. Some have come the. And
No,
they
this is the
lost
first
papers.
case I have come across till now.
They have
Abandoned case I have not come till now.
well drafted, well worded petition, I can say, Lordship, because
But
abandoned is one word. And how can he prove he has been abandoned? Who abandoned him? How did he come into India? At what age did
do
he
you
come
have
out?
the evidence of that Abul Hussein and that Dhoniram Haikia?
Abu Hussain's.
Evidence is there. What does he say?
At what age was he abandoned, Lordship?
What does Abul Hussein say? Please read.
It is Lordship.
মই গোচৰৰ 1 নং অপৰপক্ষ মই 20 বছৰ
This is before which court?
লৰ্ডশ্বিপ বিফোর ট্রাইব্যুনাল
Before the tribunal. Okay, please read.
মই গোচৰৰ 1 নং অপৰপক্ষ মই 20 বছৰ বয়সৰ পৰা পৰিয়ালসহ 1 নং নাৰামাৰী গাঁৱত বাস কৰি আছো।
This is the not Abul Hussein. Who is the man who picked him up?
Some Dhaniram Saikia and some.
No,
Tajuddin,
Tajuddin.
yes.
Where is the evidence of Tajuddin? Tajimuddin.
Tazimuddin.
Hmm.
He was not examined, lordship.
Then how can you establish your case if you don't examine Tajimuddin?
No.
The way it is submitted, Abul Hussein can take any stand he feels like. But it is only Tajimuddin who can prove that he was picked up as an abandoned person. So where is the evidence of Tajimuddin?
Lordship, as per my knowledge, lordship,
Not knowledge, evidence.
lordship, at the time of trial before the tribunal, lordship, already the Tazimuddin expired, lordship. And
Then Tajimuddin must be having some other wife, must be having some children, must be having somebody in his family
Who picked him up.
who will know about this fact.
lordship, the
Suppose your father had brought up one person, will you not be aware of it? You can give evidence. That X was picked up by my father, he was brought up as his own son in our family. You can give that evidence.
lordship,
So son of Tajimuddin can give evidence, daughter of Tajimuddin can give evidence, wife of Tajimuddin can give evidence. Where are those evidences?
only 2 witnesses were examined, lordship. OPW1 itself is the Abul Hussein, and the OPW2
Who is he?
BDP secretary, lordship.
Sorry,
BDP secretary.
what knowledge the BDP secretary has about this fact? Sorry, I think we'll have to dismiss your case. But once you bring the evidence that you are picked up by Tajimuddin as an abandoned person, then the matter is serious. We'll look into this question. But that fact, you will have to prove it, that you are an abandoned person and that Tajimuddin had picked you up. And then Dhoniram Haikia then again later on brought you up. Prove it. Where is the evidence of Dhoniram Haikia?
Lordship.
Lordship, the evidence of Dhaniram.
Then well, these are the 2 vital evidences for you. Complete fact to prove that we should do next question in down. See, Mr. Counsel, once you prove the fact that Tajuddin had picked up and brought up this person, later on, Dhoniram Haikia had brought up this person. Subsequently, again went back to Tajuddin. Once you prove this fact through appropriate evidence, that is either evidence from Tajuddin, also evidence from Dhoniram Haike, that yes, they had picked you up and brought you up as an abandoned person. Then the next stage will come, that what will happen as regards the burden under section 9 in respect of a abandoned person who doesn't know who he is. We'll decide it. But first you prove the initial facts. Otherwise, why should you go into that question? The petitioner claims that Tajimuddin had adopted him and kept him for some time, and he grew up following the tradition and culture of Tajimuddin. Later on, he was adopted by another person, namely Dhoniram Haike, who again brought him up by following the tradition and culture of the family of Dhoniram Haike. Later on, the petitioner claims that he was reverted back to Tajuddin. Petitioner claims that he is an abandoned person who does not know who he is, other than being brought up by Tajuddin and Dhoniram Haike at different stages of his life. Petitioner may produce any relevant evidence, material on evidence, which may show that he was brought up by Tajuddin and later on by Dhoniram Haike, and also that he was picked up by Tajuddin as an abandoned person, as claimed as an abandoned person in the Dharampur railway station as claimed. Bring the evidence of Tajuddin. We'll look into it. When do you want?
Lordship, some more time may be given. As it-
How much time you want?
Weeks, Lordship.
List after 2 weeks, just wait for.
Okay.
Get the evidence of the family of Tajuddin, get the evidence of the family of Dhoniram, if the two persons are not alive.
Lordship.
If the two persons are alive, bring in their evidence. And establish that you are an abandoned person. Then we'll look into your.
Okay.
2 weeks.
9th August.
But Manu Verma, if he is able to establish that he is an abandoned, then the next question will come. Those records and statements will be of almost of no use. Then we'll have to decide the implication of section 9 of the Foreigners Act vis-a-vis a person who doesn't know who he is.
But in his petition, he has stated to be the son of Tajuddin. And that is his story, Lordship. He has been abandoned. It is not.
So bring the evidence of Tajuddin, then only we can take note of
Yes,
it.
Lordship. Let us wait for that.
Nice.
Have you other copy, please?
Item 12,
Review petition. Yes, you are here, Mr. Review, what happened? Notice issued? No.
Petition.
Just give it to me, say.
During the pendency, the petitioner, review petitioner have died, already died. And
So what you want to do now?
already
I think
legal
this-
here is on the report.
He has come before an ex parte order.
Yes, my lord.
Ex parte
Ex
order,
parte.
he has filed a review against an ex parte order, Lordship.
Petitioner was,
Ex parte in the writ proceeding.
no, my lord, tribunal.
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 Tribunal, why are you finding a review petition?
No, my lord, thereafter, my lord,
No, writ petition was
Was
against
fi-
an ex parte
ex
order.
parte order, my lord, that was not entertained, my lord. And thereafter, my lord, review petition was filed.
And writ petition was dismissed.
Dismissed. my
So
lord.
you have filed a review
Review
petition.
petition, my lord.
Why was the writ dismissed?
My lord,
26 years,
Space number,
Lordship will
my
take.
lord.
I don't have the brief, but I remember little bit.
Re-
After after 26 years, there is something, Lordship. I'll
My lord,
just
page
give
number
Lordship the document.
27, my lord. Relevant, my lord.
26 years, he couldn't collect any
Yes.
document.
Yes, my lord. Petitioner got the.
So
notice.
therefore it went ex parte.
Yes, on
Not
that
ex-
ground, it was dismissed. And against that, he has come.
You don't know, why
finally
was the writ petition dismissed?
That was
On that ground, Lordship.
on that ground, my lord.
That 26 years.
Yes, sir. My lord.
Do you have a calculator with you?
Yes,
And
my-
that was.
Do you
that
have a
order was
calculator with you?
1670,
My lord,
Lordship.
may I submit what-
Mr. Sheikh, do you have a calculator with you?
My lord, in my mobile.
Don't have.
Lordship, that
If we,
order was
if we
passed
take 3,000 rupees per year, how much will be the cost?
and that order, this.
Pay the
order-
cost, go back.
May I please, my lord, may I please submit, my lord? My lord,
If you
26.
submit, it will be dismissed
Yes.
because we see no reason to review.
That is not the, my lord, ground, my lord.
But that is
Petitioner
in
received,
the order,
yes, my
Lordship.
lord, that is in the order, my lord.
How
the
can you
real
say that
facts,
is
my
not
lord,
there?
And Mr. Sheikh,
My lord.
please mind your words.
My lord.
Any misleading wrong statement
Yes, yes.
will carry
It's a
further
judicial
My lord.
order
consequences.
Before
My
this
lord.
court,
My
Lordship.
lord. My lord, may I submit, my lord? My lord, the petitioner got the notice, my lord, in the year 2017, my lord. My lord, for notice duly received on the 4/3/2017. And my lord, the petitioner for his livelihood, my lord, went to the.
Mr. Sheikh,
My lord,
we are reminding you once again,
my lord, my lord, my.
this was an offer made to you without going into any merit, that you go back, prove your case of your father.
By the legal
Ah.
years, my lord.
Either you accept it or you contest it. If you contest, we'll decide on merit.
My lord.
Then this offer will no longer be available to you.
Yes,
Which one you choose?
my lord, by the legal years, we'll conduct, my lord.
You want to go? How much cost will you pay? Now evaluate that.
My lord.
Or else you contest on merit, we'll decide on merit. We go by the strict rule of review. Where review is applicable, where review is not applicable, everything will be.
Yes, yes, my.
So you take your call.
Okay, as your lordships, my lord, pause, my lord, they are.
Poor people,
My lord,
very well.
Lordship,
My lord.
the first order.
Where is the legal right of the poor people to take the system for a right? Does the poor people,
my lord,
they are separately categorized that they can take an entire legal system for a right? No.
no.
So that doesn't matter whether you're
Yes,
poor or
my
wrong.
lord, my lord, as your
It
lordship,
depends on your act,
my lord,
the offending act that you have performed.
my lord, I'm clear.
So now how much will you pay? Yeah, this is serious.
Yes,
And
my-
this is a review which should be dismissed.
And
And
Lordship.
we see no reason.
The order which my friend has come up, that order was passed on 2017. 20, he comes before this court with a review application, and here we are in 23. So Lordship, 5 and 6, almost
That's
more
what,
than
that's
30 years
why,
have gone, Lordship.
that's why I say, take the calculator, make
Yes,
the,
it's
make
too
the
much.
cost.
Exemplary cost should be paid, should be put on the petitioner, Lordship. We
How much?
cannot take the system.
How much?
Lordship, if 3,000 per year, let him calculate it himself, 26 and another 7 years. This morning, he was seeking an adjournment and I was thinking one case less, but now I think I should have looked into it. It's so unfair to the system, Lordship.
You can't take a system for a right, Mr. Sheikh.
Right.
Your client, I mean, you cannot take it for a right. We cannot appreciate that under any circumstance. Only consideration is that this man, there is an allegation that he is maybe a foreigner and he should be given a fair opportunity to prove he is not a foreigner. Fair opportunity had already been given. You did not avail it. We are giving you a further opportunity to overcome your own lashes, your own illegalities earlier. You have to pay a cost, and cost must commensurate with the act of the person. You say how much cost you are ready to pay.
Lordship, my friend even filed an SLP in the Supreme Court. So Lordship can put any amount of cost if he has. If
No,
he can
that's why I'm
afford to
asking
go
him,
to
how much you want to pay?
The Supreme Court.
My lord, without consulting, my lord, the petitioner.
Consult. Will take up after some time. But it will be a heavy cost. Dubai. Was he pointing on first SLP was dismissed by the Supreme Court.
My lord,
Yes, Lord.
You have filed a second SLP. That is also not maintainable.
my lord.
Only thing
Supreme Court directed, my lord.
not directed, you asked.
Yes, yes.
Supreme Court does not give any direction for review. Please mind your words. Don't put the blame on Supreme
My
Court.
lord, it is, he is permitted to approach. the-
Permitted.
Right.
You sought permission, Supreme Court says, go do it.
My lord,
That is means again subject to
my lord.
applicability of the law. Not that automatically review is maintainable. That question is open. Even review is not maintainable.
How far, Lordship, they can go to stay in India?
For the first time, my lord, the petitioner received that.
Okay, you argue. We'll hear you on merit. You are interested in merit argument. Argue.
My lord, regarding, my lord, first.
So we told you,
First, my lord,
Mr. Sheikh, offer is only
Yes,
for
yes.
once
My
and
lord,
you have not availed it.
I need.
So
my lord,
that is gone now.
I need to consult with the
No.
petitioner. my lord.
The petitioner cannot decide the cost, Lordship.
Wh-
This
lord,
is the
I-
prerogative
Why
of the
should you
court,
consult your
Lordship.
petitioner?
Regarding the, my lord, cost, my lord.
5 lakhs. Pay 5 lakhs.
That's why, my lord. My lord, I may be allowed time, my lord, so that in the meantime I can discuss.
Collect
with the-
documents again. This is what is referring
Discuss
to.
with petitioners, my lord,
Nothing,
regarding the
nothing.
cost, my lord.
Court is not subjected to discussion with the petitioner.
And this is not a bargaining issue, Lordship, 20, 30, almost
Yes, my
30
lord.
plus
I'm not
years.
bargaining,
And
my lord.
every argument, cost is being raised. Mind
My
you.
lord. I pay for time.
Fair opportunity is given at the first instance, avail it. If you don't want to avail, argue.
I may be allowed time, my lord.
Lordship,
And why
this
should you give you
this
time?
review may be dismissed, Lordship, with cost. Because they
Next-
have taken the
next
whole
Monday,
process of 30 years.
I think
wastage
she
of-
is a very right and appropriate
Wastage of
submission.
judicial time everywhere, in the tribunal, in the high.
You
court, in
argue
the
on merit
Supreme Court,
that
Lordship.
offer is gone now. You did not avail it.
Maybe
on
taken
that.
a Friday, my lord, morning, I also prayed, my lord, time.
Sorry,
My-
that is also rejected.
Yes.
Why should we adjourn a matter for nothing?
I am also not my.
Just because you went to Dhubri, that doesn't mean the matter is
No,
adjourned.
my lord, I-
Says
I have-
the matter since 2017, Lordship, he knows about the whole case.
No, my lord, initially, my lord, it was conducted, Mr. Prafullo, he has died.
No, whatever it is, Lordship, he knows the
Yeah,
facts, he was
right.
seeking an adjournment, maybe thinking.
You have wasted
Another
20
time.
minutes by now, Mr. Sheikh.
My lord, I may be.
This
allowed-
matter was called at 11:15.
My lord, I may be allowed time.
No. Mr.
Lordship, I also
T.
object
Sheikh,
today.
learned counsel for the petitioner, seeks for an adjournment without stating any acceptable reason for the adjournment. Adjournment allowed subject to payment of rupees 10,000 as adjournment cost to be deposited before the list on. When do you want?
Lordship, next week, since Lordship has heard this matter, today
List
he
on, so
cannot.
they will give a
your
fixed date.
documents, Go to the factory and bring the documents and place it before the court, Lordship.
27 July.
I'm not taking time, my lord.
Next item.
Item 13,
In the morning at 10:30, a prayer for adjournment was made. It was rejected. When the matter is called, it was heard for some time, giving a fair opportunity to the petitioner as to whether he is agreeable to pay an appropriate amount of cost. So for the matter to be remanded back without any acceptable reason, and that too without any acceptable reason. The learned counsel for the petitioner refuses to accept the said offer and decides to argue the matter. After arguing the matter for a considerable period of time, again, an adjournment is sought for. And later on, it is state, a submission is made that that adjournment is not sought for. The persistent contrary stand of the learned counsel cannot be appreciated.
Lordship, on the next day, Lordship will
Will decide.
dispose of this matter, Lordship. And this matter ought to be dismissed, Lordship. No more chance should be given to the petitioner. 35 years, Lordship.
See, Mr. Sheikh, we are just observing you.
My lord.
You have the habit of playing with the system. Today also you started playing with the system for the 20-25 minutes for nothing. We are sorry to say it. Very beginning, I gave you a fair opportunity.
My
That
lord.
pay a reasonable cost, go back. We are not
That's
going.
Well, that's why I wanted to consult with the petitioner, well, how much they would pay.
Lordship, when he says
Mr.
consult-
Sheikh, you may be debarred from appearing in the court in this matter.
Sorry,
If this kind of behavior is
I'm
continued,
sorry, ma'am. I'm sorry, ma'am.
we'll
Okay,
refer
then
it to the bar council.
I'm sorry.
You are just playing with the system,
Ma'am,
nothing
I'm
else.
sorry. I am.
Stop this habit, please.
I'm extremely sorry, ma'am. I'm extremely
This
sorry.
habit of bargaining before the court is becoming too much, Lordship.
I'm extremely sorry, ma'am.
You be sorry to yourself, need not be sorry to anyone.
Yes, madam.
This is a live proceeding, watch today
I'm sorry.
what you have done.
Sorry, ma'am.
See, without any rhyme and reason, without anything, in spite of your absolutely atrocious conduct for the last almost 30 years, we still gave you an opportunity. Pay a reasonable cost, go back. But you were still trying to play with the system. Yes, next item.
Item 13,
Lordship, sometimes
See, don't take
Sometimes it
advantage
is-
of our leniency, Mr. Sheikh.
Yes, ma'am.
We are doing it for the
Madam.
interest of your client. That is,
Madam.
if he wants to prove, let him again prove his case. But you are trying to only bargain and reuse and again take different directions. This is,
I'm sorry, but extremely sorry.
pay the adjournment cost of 10,000 first, then we'll hear you. On next day.
Lordship may fix up next week,
Yes,
Lordship,
next.
27.
27.
Item 13,
Plus, Supreme Court also, you went possibly second time by misleading. You did not inform that it was earlier dismissed. Did you mention to the Supreme Court in the second SLP that the earlier SLP was dismissed? I don't think so. Where is your SLP petition before the Supreme Court? Let us take a look at it.
No, my lord.
There also you have misled the Supreme Court, mind you.
We are not in the favor. Earlier
Because
was-
once an SLP is dismissed, second SLP is not maintainable on the same cause.
it's not
If
in
you have told the truth before the Supreme Court and then this order, it is something different. Show us your SLP petition.
the- My lord will not with me. I'm fairly sorry.
Bring it.
This was-
Bring your SLP petition. Possibly it was not disclosed.
Lordship, page 43, Lordship may I draw Lordship's attention to page 43. Paragraph 8, Lordship, paragraph 7. Mr. Roy submits a dismissal of the SLP by the Supreme Court would not debar petitioner from filing a petition for review of the order passed by the writ court. Paragraph 8 says, in the facts and circumstances of the case as noted above and considering the order passed by the writ court dated 19/5/2017 and the order of the Supreme Court dated 4/8/2017, we do not find that the present case is a fit case to invoke a review jurisdiction. There is no merit in the review petition. This is the second review which he has come up with before in this court, Lordship.
Mr. Sheikh, then why
One
didn't
after the other,
you,
Lordship, this
Why are you
2018
not
also
telling
he
the
has come
truth
up with a
before the
review
court?
petition.
My lord,
you have never informed the court that this is a second review?
second review. my lord.
Why are you
On
misleading
suppression
the
of
court?
facts, Lordship.
It has further been pointed out by MS A. Verma, Land Counsel for the Home Department, that this is a second review petition after dismissal of an earlier review petition.
Review
But
petition.
the learned counsel for the petitioner, Mr. T. Sheikh, did not inform the court that this is a second review petition. The learned counsel to file a personal affidavit explaining the conduct.
Lordship, the Supreme Court order is also there, which my friend is relying on. It says, Lordship, this special leave petition of 19, where it was sent back. Learned counsel appearing for the petitioner seeks permission to withdraw this petition with liberty to file review petition before the High Court. Permission as sorted for is granted. Accordingly, the SLP is dismissed as withdrawn with the second SLP he has withdrawn with liberty to file a second review petition here.
Second review petition.
Yes, that is why he came up with this petition, the review now. So much of contradictions in his own thing, Lordship. No, that was,
Mr. Sheikh,
My lord,
you should always be fair to the
my
court.
lord, my lord,
You are not.
my lord.
Supreme Court did
actually-
not grant him permission. The order passed by Justice Bhuyan Silo. He challenged that order before the Supreme Court. Supreme Court, I think he must not have mentioned because it was dismissed to file another here. I do not know how he's getting these orders, Lordship. All one contradicting the other.
Hear you next. First, petty cost.
Lordship, the cost has to be more suppression of all the facts. He's not coming with clean hands to the court at all.
I'm sorry, my.
Lordship, sorry doesn't change anything, Lordship. 30 years, everything gone. And again, one lie after the other.
This was.
This is not fair to the court and to yourself also.
You are neither helping your client nor you are helping yourself. And with these kind of misleading statements before the court, Mr. Sheikh, you are also taken note of. Next time Mr. Sheikh comes, you will have to be very careful. Court always works on a faith. And we have great faith on the learned counsel.
Sure, my.
But by your conduct, if you make the court to lose its faith, then accept the consequences also.
Sorry.
We'll hear you next week. Yes.
Item 13,
Last time, probably to write one time with Bushi Galama.
Yes. Item 13.
Yes, last order to be actually.
Last order to
Lordship, can this matter be taken up next week, Lordship?
Next week.
Yes. Lordship,
don't
our
know the-
file is missing, so we're
I
taking.
don't know the inconvenience and the state government. So this next week. System. It does. Yeah, I assume. Yeah, team does. Okay, come back.
Your Lordships, the petitioner is the Akbar Ali Lordship. The 66 voter list, his mother and
Petitioner is the Akbar Ali.
petitioner is Akbar Ali Lordship. And the Lordship, 66 voter list Lordship. The 34
Page-
Lordship,
Page number.
34. Ufatan Nessa, mother, Imtaz Ali, brother,
Ufatan Nessa is the mother and Imtaz Ali is the
brother.
brother and mother. This is of which year? 66.
66. Gorola is the same voter.
It is Gorola.
Gorola.
So petitioner is Akbar Ali.
Actually, with the page 37. Look. 1977 voter list. Look. Translated profile looks
Page 37.
37.
Lordship, may I just draw Lordship's attention? After filing the WS, petitioner never went back for the next stage, the argument stage. And if this opinion was passed,
Expert.
not kind of expertise, but he
After
just
filing-
filed it.
After filing of the evidence, Lordship, his ailment and due to erosion, he could not appear before the tribunal.
Ailment and erosion,
Erosion, Lordship.
both.
Lordship. The page Lordship type could be order Lordship, page 60 Lordship.
So now what do you want? These documents are filed for the first time before this court, or it was on record before the tribunal?
The file evidence in shape along with documents, Lordship.
We have filed it.
Yes, Lordship, but he could not prove these documents, Lordship.
Need not prove document. These are certified copies.
Yes, Lordship.
Certified copies need not be proved. No, certified copies proof করবো না লাগে. What do you do? Go back
He can go back, Lordship, and he
after
can
payments of some cost.
some cost also, and from the argument stage, this matter may be again reopened and passed on merit, Lordship. Because the first stage is already gone. No
Yes.
more fresh documents, nothing, because.
No,
he's
this is
already-
good enough for him.
Yes, Lordship.
Whatever is filed, if it is
Yes.
accepted, it is good enough.
Yes, Lordship. That may,
Heard,
from the stage of argument, it can go back.
heard Mr. N. Ahmed, and how much cost will you pay?
2018,
3,000.
Lordship, he is aware of his case from 97. Until date, it has not been decided because of his fault.
Lordship,
So
page-
Lordship 2018, this opinion was passed. It's already 23 now. So Lordship will give him last chance, some cost, and he can go and get it.
Cost how
adjudicated.
much?
I leave it to your Lordship. Lordship, if Lordship will not, imply some cost, this will continue, Lordship.
How much cost will you pay?
Lordship, 3,000.
At
3,000,
3,000, Lordship would. get
3,000,
it.
Madam Verma is also ready to give it to you. If you ask her 3,000, she'll give it to you.
It is not this Lordship.
Cost must be
It is,
something which will be a little deterrent later on,
Yes, and they will.
not
see
casual.
to it.
A reasonable cost, Lordship. maybe.
Sorry,
A reasonable cost, Lordship.
what will be the reasonable
Petitioner
cost?
is
To
the full family,
stay
Lordship.
without documents in India from 97 till now, how much more reasonable, they want us to be reasonable.
You want to
Lordship.
go first? 5,000.
Yes,
Heard
Lordship.
Mr. And Ahmed, counsel for the petitioner. The petitioner Akbar Ali had been referred to the Foreigners Tribunal
Lordship.
number 1 Borpeta
Borpeta.
for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number 139/20/17. Tribunal rendered an opinion dated 4/12/2018, declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 and 1970 of village Gorola, police station Bagbor in the present Borpeta district, which contains the name of Afatan Nessa, wife of Hakimuddin at serial 366, and Intaj Ali, son of Hakimuddin at serial 367, in respect of the voters list of 1966, and serial number 404 and 405 in respect of the voters list of 1970. Petitioner also relies upon the voters list of 1977 of village Gorola, which contains the name of Ofatan Nessa, wife of Hakim at serial 564, Intaj Ali, son of Hakim at 565, and that of Akbar Ali, son of Hakim at serial 566. Accordingly, it is claimed that the petitioner has discharged the burden under Section 9 of the Foreigners Act 1946, inasmuch as his name Akbar Ali appears along with Ofatan Nisa and Intaz Ali in the voters list of 1977, whereas the name of Ofatan Nisa and Intaz Ali also appears in the voters list of 1960 and 1970. M.S.A. Verma, Land Counsel for the Home Department, has raised an objection that before the tribunal, the petitioner filed written statement as well as the evidence as indicated above, but thereafter discontinued further appearance in the tribunal, which resulted in the opinion dated 4/12/2018. Accordingly, it is submitted that the matter be remanded back to be continued further from the stage of argument. Full stop.
Lordship, cross was not done. Filing evidence, the cross was not.
Cross. It is their problem, not your problem.
Yes.
Full stop. In view of the above, matter stands remanded back to the tribunal to take a fresh decision on the claim of the petitioner that he is not a foreigner by taking note of the voters list of 1966, 1970, 1977 of Videsh Gorola. But for the conduct of the petitioner in not appearing before the tribunal any further, after the initial stage, the petitioner to pay a cost of rupees 5,000 to be deposited before the advocate, High Court advocate, and the petitioner to appear before the tribunal on fixed date,
11th August.
after showing proof of the payment of the cost. The respondents in the Home Department may make their verification and submit report before the tribunal, as well as to produce any further material if so advised, as well as to cross-examine the witnesses of the petitioner. Upon doing the needful, a written order we pass.
Masum.
Time being 7.
Right, please, your lordship. Lordship, it is a contested case and the petitioner declared foreigner, lordship. Lordship, in this case, there are 4 DWs deposed before the tribunal. Petitioner's father, mother, brother, and self, lordship. The Impian order 30/06/2022, lordship, and access 6 page 45 to 55. Lordship, petitioner's grandparents, father, mother, and brothers' name appeared in the voter list. In the voter list of 1965, Annexure 7, page 56 to 57, lordship. Here, her father's name appeared. Isabali.
Isabali.
Son of
Sobali is the father or grandfather?
father.
Father.
Grandfather Rafetullah. Grandfather Rafetullah.
Rafetullah grandfather. Isobali father.
Father. Javeda Khatun,
And
mother.
village Borghopa Bilor Kothar. And Javeda Khatun,
Mother.
mother. Okay. Now, who is the petitioner? Jamirat Desa.
Samiran.
Which document will show? He is the daughter of Isob.
Lordship, there is a copy of Jamabandi, lordship, Annexure 11, page 64 to 68.
This is Jamabandi,
Yes, lordship.
village Borghopa Bilor Kothar. Patadar Abdul Jalil Edumia.
Page number 65, Lordship.
Mm.
As per Circle Officer's Order 68/2018, her name is mutated. In place of-
Jamira Nessa, daughter of Edumia, in
Edu.
place of Jabeda
Deva.
Deva. Jabeda, okay. So Isob is shown as Edu.
Yes, Aesop and alias Edumia.
Where is the vernacular? Is it Edu or Isob? Just take up.
Vernacular one is
Page 60.
68.
60.
Name of the father is different, Lordship.
Edu.
Edu
Edu.
and the father is Isab Ali.
Isob, huh? That's what I asking you.
In place of Jabeda Deva.
God.
Lordship, the fathers' names are different even from page 64. The sons are also both are sons of late Edumia, and here it's Isab.
No, no.
Whether Isab Ali and Edumia are same or
Trying to look at it that only.
Voter list as well, 65. I think.
See, if you come to the voters list at page 56,
yes,
Yes.
Lordship.
Abdul Jalil is there, Isob Ali is there, both are sons of Rafetullah.
Yes.
Okay.
Yes,
Now, if you come to page 66, can you read the vernacular?
My friend will read it.
Mr. Sharma, just check up.
I read it, it take the whole day, Lord.
First,
If I read it, it take the whole day.
first is Abdul
Jolene.
Jalil, second is Idumia. They are sons of
Rafetullah.
Rafetullah. Sir, Rafetullah father's name is common with the voters list of 56, page 56.
Yes,
Hmm. So Abdul Jalil is there, Isob is there. They are the sons of Rafetullah. So there is a good possibility that this Edu and Isob, they may be the same person. The village is also same.
Yeah.
So do one thing. You send it back, you make a verification. Whether you find Edu and Isob are same person or not.
Yeah.
If you find they are different person, it cannot be accepted. But if it is same person, otherwise other names are telling.
Yes.
Mhm. Harur. And Rafetullah is a little uncommon name.
Yes.
It's not one of those common usual ones that keep on appearing. Yes.
Yes.
T Begum.
Hmm?
T Begum.
Anything more you want to say?
That's it.
Do you want to submit anything more?
Lordship,
Well, we have seen.
after married with Abdul.
Or this is good enough for you.
What's in his role?
This is good enough. Then the question heard MSP Begum and counsel for the petitioner. Whose name I put? Sharma or Madam? Counsel for the petition, respondent, but it's already go. The petitioner, Jariman Nessa, had been referred to the Foreigners Tribunal number 10, Borpeta, for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number 1848/2018. The tribunal rendered an opinion dated 36/2022 declaring the petitioner to be a foreigner, being aggrieved the said petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Borghopa Bilor Kothar, police station Horbog in the present Borpeta district, which contains the name of Isab Ali, son of Rafetullah at serial 46, and that of Jabeda Khatun, wife of Isab at serial 47. It is claimed that Isab Ali is the father of the petitioner and Jabeda Khatun is the mother. We also take note that the voters list of 1965 contains the name of Abdul Jalil, son of Rafetullah, where Abdul Jalil and Isab Ali both are residing in the same house number 7. Reliance is placed on the Jamabandi of a plot of land at village Borghopa Bilor Pothar, which contains the information that in respect of the plot of land, in place of Abdul Jalil, son of Rafetullah, and Idu Mia, son of Rafetullah, mutation had been made in favor of their legal heirs. The Jamabandi also contains and refers to an order of the circle officer dated 6/8/2018, by which the name of Jamiran Nessa had been mutated in place of Jamiran Nessa, daughter of Idu Mia, had been mutated in place of Jabeda Khatun. It is noticed that Jabeda Khatun is the wife of Isab Ali as per the voters list of 1965. And as the name of Jamiran Nissa had been mutated in place of Jabeda Khatun by the order of the circle officer, it is claimed that the petitioner had discharged the burden under Section 9 of the Foreigners Act 1946 to establish that she is not a foreigner under the said act. The Jamabandi also refers to the name of Abdul Jalil, son of Rafetullah. In the circumstance, a question would remain as to whether Isab Ali of the 1965 voters list and Idu Mia of the Jamabandi, in respect of the same village, Borghopa Bilor Pothar, are one and the same person. If a conclusion can be arrived that they are one and the same person, the petitioner may have discharged the burden under Section 9 to prove that she is not a foreigner. And on the other hand, if Idu Mia of the Jamabandi and Isab Ali of the 1960 voters list are not one and the same person, such burden may not have discharged. In view of the above, remanded back to the tribunal to consider the voters list of 1965 of village Borghopa Bilor Pothar, as well as the Jamabandi and the contents thereof in respect of the plot of land at village Borghopa Bilor Pothar, and pass a reasoned order. And more particularly, a conclusion be arrived as to whether Isab Ali of the 1965 voters list and Idu Mia of the Jamabandi are one and the same person. The petitioner may produce any further material, if so advised, to prove that they are one and the same person, whereas the respondents in the Home Department may also make their own verification and submit a report on the aforesaid question as to whether Isab Ali and Idu Mia are one and the same person. Upon being the needful, a reason will be given.
And it's a obligation.
Yes.